the idea for me today is in 20 minutes to present some selected challenges of open data licenses and collective governance of data, where I will just select from insights from an upcoming publication forthcoming in a few weeks in a Swiss journal, where I explore how to extend open licensing models to all kinds of data, from complex data sets to single data, whether copyrightable, technical, or personal data. The idea is to increase data sharing and data flows, but at the same time to increase also the control rights of individuals. And to ensure implementation and enforcement of these new licensing models, I suggest to combine these models with data trusts, i.e. independent agent that will then promote, implement and enforce this license. The starting point of this is that data sharing is central for the development of artificial intelligence, which we know rely usually on a large amount of data, but it's difficult as data are mostly subject to a multitude of rights and actors. Think of a self-driving car that generates billions of data, many of them being subject to different legal control rights and ownership claims. For instance, ownership rights of the car producer, the car driver, the car owner, even the service provider or the insurer. And all of them may have good ownership claims in the data. So to manage these claims, contracts seem a flexible and good option. And among the contracts, I thought it interesting to rely on open licensing so as to increase, as mentioned, to increase data flows and data sharing. Few definitions. Open licenses are voluntary standardized licenses, according to which the creator grants an authorization to use the object, for instance, the image or the software as an object, to any users willing to abide by the contracts. Traditionally, open licenses are used for copyright and softwares, and their benefit for AI is obvious. Think of open source software such as the MIT or the GPL licenses used by many developers to create and enrich AI models. And even according to a European study, it helps mitigating discrimination and bias in machine learning systems. Think also of open images, such as Creative Commons used by Wikipedia or Deep Dream to generate a Google Dream image. However, open licenses generally exclude other kinds of data, such as personal and technical data. Yet, these other kinds of data are also everywhere. Think of urban and map data for smart cities, Google or OpenStreetMaps. Think also of CAPTCHA data, this small verification program used by a website to confirm that I am not a robot. But at the same time, this CAPTCHA data may be used to train AI. So it seems interesting to shape an open licensing models that applies to all kinds of data, as well as personal and technical data. Yet, shaping such an open licensing model raises different challenges. And for today, I selected two challenges. One, how to extend open licensing model to technical data, and two, to extend it to personal data. Please note that due to time constraint, I will not address issues such as liability or compatibility between models, but happy to discuss that with our commentators after. So the first challenge relates to the validity of open licensing when it applies to technical data. As mentioned, technical data, think of the OpenStreetMaps or CAPTCHA data, might be everywhere as well. There exist few licensing models that try to capture technical data as well, but they are usually only valid in relation to database sui generis rights, not the individual single data, and usually only in jurisdictions that recognize a database sui generis right, such as in the EU. And that is the case, for instance, with Creative Commons or the Open Database Database License, ODBL, used by OpenStreetMap, that try to capture technical data, but only in relation to database sui generis rights. So one can think if and how to extend such open licensing to individual single data, or at least to the databases in jurisdictions with no database sui generis rights. And I think an avenue to explore is how to make such license valid and binding towards any users, possibly by attaching the contract to the object, similarly as with Creative Commons and open source software, where the contract is always attached to the image or the software. So the contract really follows the digital file, the digital data. This would be a little bit in line with the Ryanair decision of the European Court of Justice, implying that contractual terms may be valid and prevent web scrapping when website users have validly agreed to the terms and conditions. And here we would consider that open licensing may be also validly enforced towards any users, as the terms, as mentioned, are always following the digital file, the data. More concretely, to shape such a model, one could rely on the recent Linux collective data sharing agreement that tries to cover all kinds of data in a simple manner. You have here the reference. Briefly, second challenge relates now to the validity of open licensing when it applies to personal data. And as mentioned, with CAPTCHA data or any kind of data, they are mostly personal data as well. Such extension seems feasible due to the similarities between personal data and copyright. Both objects relate to an exclusive right, and they have an unwaivable protection, copyright with the unwaivable protection of moral rights, at least in some jurisdictions, and personal data with an unwaivable control right, such as the right to withdraw consent at any time. No standardization exists yet, with few exceptions, such as the Salus COP license for health data, or the license of City of Lyon in France for urban data and civic urban data. So concretely, the model can get inspired by these pre-existing licenses and could also include additional obligations, such as the obligation to pseudonymize or de-identify the data, and also to provide an opt-out mechanism, as mentioned, due to the unwaivability protection of personal data. I think this would foster the concept of data altruism, i.e. data voluntarily made available by the data subjects for the common good, such as public health or scientific research. And you probably have heard about data altruism, a concept that is now fostered by the Data Governance Act in the EU and even by some health-related projects. There are now, however, additional challenges, of course. At least let me mention here three. One is to know how to deal with the privacy paradox, in particular with the fact that data subjects usually consent blindly or even do not care about managing their data. Two is to know how to implement an efficient opt-out right when a data subject wants to withdraw consent. And three, to know how to deal with unrepresented population, i.e. when only some data subjects rely and accept to rely on data altruism, while others do not, which may lead to unrepresented population, unrepresented data, and we know that it leads to possible algorithmic bias. So to remediate these additional challenges, following solutions could be envisioned. One, for the privacy paradox, the licenses could be promoted and enforced by data trusts, i.e. an independent agent that would promote and enforce the license. Two, for an effective opt-out mechanism, the data could include a digital tracer so as to trace and extract the relevant data when a data subject wants to opt out. And I know, for instance, in medicine and in some hospitals, there are ongoing projects for dynamic consent, also to trace and to extract the specific relevant data. And three, for unrepresented population, one could even consider, and that's very, very provocative, nevertheless, could consider to extend the license to unrepresented population for certain important projects with an ex post opt-out mechanism, similarly as with the copyright extended collective licenses that some Norway and Switzerland, Swiss law knows in copyright law, or even with exceptions in the medical research field. Finally, few words about data trust. I will be brief on that, just to mention that these new licensing models could be combined with data trust, an independent third party, so as to ensure the promotion, implementation, and enforcement of these mechanisms. And of course, data trust, we hear a lot about that. And we read that there is no unique definition and can take different forms, from simple partnership to cooperative or associations. But they can be shaped in an appropriate manner based on lessons learned from pre-existing initiatives. Here, I think, for instance, of Sidewalk Lab, the smart city projects for Toronto, and lessons learned, for instance, that it's key to have inclusiveness, an appropriate decision mechanism. And we can also shape the data trust based on copyright collective societies such as Suiza or Swiss Perform, because I think they fulfill almost all the data trust requirements or the lesson learned that I mentioned. So to finish here, the following questions will be addressed in the publication I mentioned, also in future research, and happy to discuss that now with our commentators and you also participating remotely. First, concluding remark with respect to open licensing. Assuming that we shape an open data model that extends to all kinds of data or can capture as many data as possible, the next question will be how to ensure compatibility and interoperability with other pre-existing licensing models, because we know there are a lot of other open licensing models, and it's key to have an open licensing model that is compatible with the others. Second, a concluding remark with respect to data trust. Assuming that we identify the appropriate structure, as mentioned, potentially based on the lessons learned and on the copyright collective societies, the next question will be how to ensure the promotion and effective implementation of these models. In other words, is a data trust sufficient to really promote and ensure enforcement of such models? I think, for instance, of the opt-out right to be enforced and effectively implemented. So these questions complete my presentation. At the end, I included selected resources to dig deeper, including our commentator, Professor Dr. Mélanie Dulong-de-Rosny. I very much look forward to discussing with our commentators and other participants. Thank you very much for your attention.
Thank you very much to Professor Benamou for this stimulating presentation showing how many issues need to be further explored, and also for identifying interoperability as one key question. I think it's interesting also to look at interoperability not only from a technical perspective, but also from a legal perspective. I think we need also to have legal systems which do work in an interoperable way. Let me now give the floor to our first commenter, and you can either stay or come, whatever you prefer. That would be Professor Loison. Thank you very much.
Thank you very much for inviting me for this interesting presentation. Some thoughts about what you presented. As you mentioned at the beginning, I'm working for the Federal Statistical Office, and as you know, we take care of the data in a very special way, as well, especially regarding data protection. And I would like to comment a little bit your research, and maybe I will start with data trust. I think the idea of data trust is a valuable idea. I think maybe we should also consider that the experiences that have been made around the world regarding that. And one very good example is what happened with the project Sidewalk, and especially it was in Toronto 4 or 5 years ago, I think. And they started at the beginning. Google was behind this project, if I'm not wrong, and after that they have a lot of complaint with this project because it was they wanted to know everything that happened on the sidewalk. In Toronto, it was a test, and they have a lot of criticism from the citizen. And Google decided to create a company, civic trust data, I think something like that. And it was an independent company, and even with that, it was not enough. And now they are thinking about giving the responsibility to control that to the government. I think the idea is good, but probably we have to consider also how the population will react to this idea. The other things that I would like to mention is a little bit the business model from these data trust. And we need, if we want to increase the trust in these data trust, we need to be sure that the business model of this company is very clear and transparent. And the last thing that I would like to mention is data trust has something to do with the kind of the data that we are talking about. I think it's not the same if we are talking about data from smart city or something to do with the temperature of the air, or something like that, or if we are talking about health data, or if you are talking about something else. And I think probably it will be necessary to a little bit to differentiate the kind of data that we are talking about. The second part that I would like to comment is a little bit, it's a much more difficult question, is the first question. And I think I tried to give my thoughts about the model, the actors in this system. And currently, I can speak, for example, for the open government data, you have a very clear system. You have on one side the government, they prepare the data, they anonymize the data, and they bring that on the portal, and you have a community that uses this data. The deal is very clear. The data that have been collected by the government is under the responsibility of the government. The government has to ensure that the data that are published are open data, fulfill the need of open data, which means anonymized and so on. And with the idea of a license, I think the idea is, again, is a good idea, but I think you shift the responsibility to the owner, the data owner, which means to the citizen or to the company, the enterprise. And the question I'm asking myself is, who will really be responsible to ensure that these licenses are respected? Do the citizens really have time to do that, or even the enterprises? And that's maybe my thought about the model, the first comment. The second comment is about the transparency of the process. I think from the legal point of view, I think it's okay, but the reality at the front, when you have to deal with data science process or with artificial intelligence process, is probably a little bit more complicated than that, which means you have raw data and you need to prepare the data, and after that you can use this data with an algorithm. And I will be very interested in a very positive way to understand how you will deal with all these transformations, because at the end of the day, the raw data are transformed in a sort of way in order to be usable by algorithm, the cleaning part of the process, if you want. But again, I think that's maybe my last comment, and I would encourage you to move forward with your research, because I have a very concrete example. The Eurostat is the European Agency for Statistics, and wanted to have a tourist accommodation market information and data, and we knew, and they knew, if we want to have this data, we need to access to data that are stored on platform. And this collaborative economy, if you want. And it took really a very long period of time to make a deal with 4 companies, that's public, that's inspection, Airbnb, Booking, Expedia, and TripAdvisor. And it was really complicated to find a way with this company because, of course, they are using the data that the user put in this platform. And at the end, it was quite a big, complicated contract at the end to have access to be more than 25 variables. And that's the reason why really I encourage you to dig deeper with your research, because I think we are living in a new ecosystem where data are located in one place, the owner are located elsewhere around the world. And if you want to use the data relativity the way that you mentioned at the beginning, I think we need to probably to find another way to deal with this question. Thank you.
Thank you very much for these very thoughtful comments. I would suggest, unless Professor Benamou wants to react now, to perhaps move to the next commentator, and that would be Professor François Gray.
Yes, thank you very much. And first of all, I'd like to say that I'm a physicist by training, so I've been brought up with physical laws, not human laws, and I tend to make mistakes when I try to transfer knowledge. So I probably will show some ignorance here. I give a course on open science and I start next week, and there's a good chance that this discussion will improve the contents of my course considerably. What I enjoy in that course, actually, it's to scientists in IT, is that they're often totally unaware of the legal issues underpinning many of the terms that they are aware of, such as open source. And so it's quite interesting to quiz them about this and to have them read up about these issues. And they often come back and say, oh, that we didn't realize how complicated it was. One of the things I tell them, and again, this may be a physicist's interpretation, is that the data is different from intellectual property, at least scientific data. And I quote the WIPO to them. Intellectual property refers to creations of the mind, inventions, literary and artistic works and symbols, names and images, and designs used in commerce. And then I say, well, that means the copyright law does not necessarily apply to data, facts, or ideas. So when we talk about open data licenses, I guess one of the questions is, what actually does this apply to? Now, to take, this is a physicist's approach, I guess, is to take an extreme case and consider it. So I have a colleague in the UK at Cambridge University, Peter Murray Rust, who many years ago set up a project called Content Mine. And the basic idea of Content Mine is that since the scientific literature is a part of it is not open, is closed, but since the data that is published in scientific articles is scientific data and therefore doesn't fall under copyright, he's been setting up systems to scrape that data out of articles and make it available on the basis that nobody will have the courage to take this up legally, given the definitions of scientific data. And so far, to my understanding, this has worked out reasonably well for him. So I wondered, one of my thoughts was, what do you think about these sort of categorical definitions of data and how that would impact what you're describing in terms of setting up open data licenses. The other example, and this comes to the trust issue, again, taking a sort of extreme example from open science, is a project called Open Humans, which you may have heard of, which invites people to upload essentially all their genetic data, health data, as part of a research effort. So essentially making all their personal data completely available for research projects. And there's many people, there's other projects like this, but Open Humans is one that gets a lot of attention in the press sometimes. And again, here we have an extreme example of a lot of data being shared. So this issue of trust, what does it mean if a subgroup of the population is suddenly totally transparent about data? What does it mean for everyone else? In particular, the issue that often comes up is, what if someone in my family joins this project? They're essentially sharing part of my genetic data as well. What are the legal ramifications of that? Can I ask to have data removed because it actually says something about myself? So I wanted to put out there these two sort of extreme examples of how people are moving towards much more open forms of data sharing, and ask you how that impacts your thoughts on data trust and on open data licenses. Thank you.
Thanks very much for showing us, at least showing me, how diverse and extensive open access can be, including by Opening Humans, as you just mentioned. Let us now listen to our remote commentator. Many thanks to Mélanie Dulon-Deronet for joining us today. Mélanie, you have the virtual floor.
Hello, everybody. Can you hear me well?
Yes.
Yes, I can even see the bottom of my face on the screen. That's perfect. Thank you very much for inviting me to this event. I was so happy, so excited when you sent me the invitation, because the title of the event and the content of your paper, which I read just before the event, is perfectly aligned with my current and next research projects, and the collaborations which I'm going to describe briefly now during this commenting part. So first, I will be working within ODECO. I'm going to share that so that at least in the chat, at least the remote person can have a look. Here you go. So ODECO is a distributed doctoral school, interdisciplinary, which aims at building the ecosystem for user-driven, circular, and inclusive open data. And as it was underlined during the previous talks, there is a need of business models, of technical interoperability, and of course, legal interoperability. And I'm going to co-supervise a PhD in law to think about the new legal instruments, the new open licenses which are needed and which need to be the second generation, or maybe the third generation of open licenses. Because first we had the Creative Commons licenses applying only to copyrightable works. Second, we had with CC0 and the Open Data Commons, the Open Database license. We had licenses which were as open as possible, as close to the public domain as possible, and which were matching the needs of open science and also of public sector information in order to remove as many legal friction and as many legal restrictions as possible. And the third generation of licenses, as underlined in the paper of Professor Benamou, needs to bring back restrictions. Restrictions, for instance, for medical data or for personal data, or for private platforms, private companies. And the need is not only to identify the legislations which will require a restriction or an opt-out, as it was presented in the paper, but also to provide incentives for private parties to use the scheme which we're going to design. And I'm going to share it also in the chat, the second project, which also is going to start at the end of this year. So first, the ODECO European Doctoral School on Open Data. And second, it's a bilateral project between France and Singapore on urban AI, because an urban citizen data of smart cities. And I'm particularly excited about this collaboration because it will provide the perspective not only of civil law, which puts an emphasis on personal data and on responsibility. And in this respect, I'm perfectly aligned with the findings of the papers based on Swiss law, because it's very close to French culture and legislation. And with Singapore, I hope that it will bring the perspective of another culture and of partners with another conception of smart cities. And last but not least, to build this third generation of licenses, I'm developing a partnership also with Open Knowledge Foundation in order either to update ODBL or most likely to write another set of licenses. So I hope that this event of today is the beginning of a broader conversation where we will identify not only the legal needs and possible solution, as it was underlined in the paper, but also think about incentive schemes and perhaps devise the framework for a data trust or a data pool agreements, like it was also described in the paper.
Thank you very much, Melanie, for sharing your thoughts, but also your ongoing and future projects. And we, of course, be delighted to discuss about the ways how we could cooperate in the future, but that's probably not the right time to do so. And also for showing how important interdisciplinary approach is for these issues, including about incentives, as you just mentioned. Let us now give to Professor Benamou the opportunity to perhaps react to selected aspects and points which have been raised by our commentators before, perhaps if of interest, opening the discussion with those of you who are with us today and also those of you who are attending the event remotely. But first of all, Professor Benamou.
Okay, I try to briefly react. Hi, Ms. Dulong, by the way, we have never met yet, but good to meet you. Many thanks for your comments. I will start with yours and then with Professor Gray and Mr. Loison. So very happy to hear about your project with Odeco. So I will definitely look that into detail. Happy to start this conversation as you meant, probably for a broader conversation. Very happy if we can contemplate some designing framework, and happy if I can or we can from the Digital Law Center try to help shaping the framework. One strength, one specificity I would say from here at the University of Geneva is also to try to work mostly with an interdisciplinary approach. Of course, we keep our vertical expertise approach, but we also try to have interdisciplinary approach. And as you said, this framework would definitely need to have an interdisciplinary approach. One thing is legal solutions, legal compatibility or interoperability, but then we need also to look at technical interoperability and also the economics. As you said, there is a need to have incentives. So happy to start conversation and we'll be in touch hopefully. Back now to the comment of Mr. Professor Gray. I would just say with respect to content mind, it's interesting this project you meant that there is probably a mining or reuse of data as long as they are not published yet. And you were wondering what would be the impact of open licensing models. I would say the model of this content mine project is interesting to the extent that IP exists wherever the data is. So before commercialization, before publication, there is already IP, and after as well, with this idea of mining or reusing data before publication is probably assume that there will be no enforcement or that the data is under open licensing models. And after the publication, probably that the publishers try to bring further legal restrictions. And that's why I think, and I'm coming to the main point, we speak about réappropriation du domaine public, the reappropriation of public domain. Of course, that's the fact for some publishers. That might be the fact for some businesses when they reuse and they try to appropriate some technical data that are potentially without any IP rights. And therefore, I think this legal framework with open licensing models, as Dr. Dulong mentioned, probably a third generation, would also avoid bringing new legal restrictions, new reappropriation. And therefore, this content mine project would be probably feasible also to mine the data also after the publication. So again, key words, I think it's the avoid public domain reappropriation. Briefly about what you mentioned about biometric genetic data to know where they are, also if it could be potentially of your ancestors, thank you. That's a pure data protection and personality rights issue. Happy to discuss that later, but for the sake of time, I move already to Mr. Loison. With respect to Mr. Loison's comments, I was very interested in the business models you mentioned. It's key to have business models, and I think this echoes what Dr. Dulong mentioned when there is a need to have incentives. Interestingly, when we talk about economics, on the other hand, the Governance Data Act in the EU is also assuming that there might be new data altruism organizations with non-profit approach. So, but they are both. They are non-profit data altruism organizations as well as intermediaries that may make profits. But just to say that you are right, business models is probably key. Interestingly, Europe is also trying to see whether there shall be also non-profit data altruism. And finally, you mentioned the dynamic nature of the data, for instance, for AI, and you're right, there is a lot of clearing process, preparing the data, selecting the data. And I think that's exactly why such a third generation of open licensing model would be interesting, is because, again, it would avoid reappropriation of public domain data. And also it would cover and tackle all these types of data as well as the dynamic nature. So regardless of the process where the data is refined, affined and reworked, this open licensing model should be, if we design it well, applicable. And last comment also, you mentioned a very important thing about the difficulty to access to data sometimes when they are sent abroad and stored in GAFAM or whichever businesses. And exactly one upside with this open licensing model would be to recap, to refine this data sovereignty, la souveraineté des données that we speak more and more also in Switzerland, because then individuals would define themselves or through data trusts the terms of and conditions under which their data may be used, so as to increase the data sovereignty and to avoid reappropriation. I guess, Jacques, if you have also comments, I would be happy to hear.
Thank you. I think we'll have other opportunities perhaps to interact, but we've been discussing about this issue. I think it's great to see also and to have various perspectives, and perhaps it's the right time now also to give back the floor to the commenters who may actually want to specify or react to what Professor Benhamou just said. Melanie Dulon, any reaction to what Professor Benhamou just indicated?
No, just more positivity and complete alignment with the research agenda, because I completely agree that it's key to also devise mechanism to avoid the reappropriation of the public domain, or at least devise mechanism in which would contribute back either to the public domain or to the commons. So yeah, that's that would be my additional +1.
Thank you.
Thank you
very much, Professor Gray and Professor Loison. Any reaction to who you would like to start?
I'll briefly comment your what you said. I think you addressed the points that I wanted to highlight. The dynamic of the data, that's a real question, and we need to find, in my eyes, a solution if you want to move forward regarding these thematics, this topic and the other things. I think you mentioned the business model. I think, yeah, we need to think very deeply about which business model should this data trust have, and if it's, for example, possible that they have a business model where they can generate benefit in this position. And I agree with you, that's probably one way that we need to follow is probably the non-profit organization, non-profit business model. So thank you for the reaction. I think I agree with you.
Perhaps I'll just add on the content mine example. In fact, to be clear, that project has been making data from published journals available on the basis that although the scientific article is subject to copyright, the scientific data in the article isn't. That is the basis, at least, of the project. Now, whether that stands up, whether that would succeed, and if it was challenged legally, I don't think we know the answer yet. But I guess what I'm really getting at is these edge cases, people really pushing the envelope on what are, can data be licensed, or can certain types of technical data be subject to license. These are probably very interesting places to go and look for, what the next model should be, or how they should apply.
Thank you. Now time is for opening the floor, the real and face-to-face floor, or the virtual floor, with participants who are joining us remotely. Any comments or questions are most welcome on the chat, or in any other manner, also by taking the digital floor and raising your hands on the Zoom platform. We have a question in the room, and the mic is on its way, thanks to Marion Consoli, whom I thank.
So I have an ethical question regarding the sharing of personal data. So I was thinking that, well, in general, when we share personal data, there is always a risk involved in doing that. And it's not clear what the benefit for people would be in doing that. And I think it's exactly why you call it data altruism. But then, is it fair to ask them to do that? Or is it some way of taking advantage of people's ignorance of the risk involved, or taking advantage of their benevolent nature?
Thanks very much for the question. And I would turn to Professor Benamou.
Thank you. I was expecting
have an answer to that.
I was expecting this kind of question, because it's key what you said. Is there any benefits? And as we know, with the privacy paradox, or we speak about legal sociology when we observe how people do not care about their data, or they do not have any idea what about their data are reusing. And that's actually, I think, one of these benefits, assuming that we do that through data trust, is that only data subjects that are interested in participating in this data altruism approach would join the data trust structure, and then put their data voluntarily. And assuming that the data trust also push GAFAM or other big businesses to adopt this kind of very respectful, compliant with privacy laws licensing mechanism, this would increase, I think that's the benefit, would increase the control rights and the data protection of individuals. And that's why I was speaking about control rights, data sovereignty, because again, that data subject then may define under which conditions their data may be used. Otherwise, that's the businesses who decide that. And I think CAPTCHA is an interesting example, because we all use CAPTCHA to know, for the website to know whether we are not a robot. But if you read the privacy issues, apparently there are many privacy issues, because they reuse this data for training AI, but many of them are not fully anonymized. They are just to a certain extent, de-identified, and therefore, without knowing, actually, we are training CAPTCHA. And have a look at the privacy policies of these businesses when they use CAPTCHA. I can assure you that open licensing model could be more respectful of our privacy protection.
Thank you very much. Any other question or comments, remotely or locally?
Just to add and to finish on this interesting comment about ethics, I was talking about interdisciplinary approach at the University of Geneva, and of course in many other institutions. And ethics would be definitely, for the legal framework, something to consider very strongly.
So I think there's also another question. No, please. So please take the mic.
It's not okay. So like, it's related to part of the discussion. So I work in natural sciences, and I'm very interested about this concept, whether intellectual property spreads and facts? I mean, because I don't think I heard the answer to this. Is it possible to have intellectual property on facts about nature that we derive? We heard an extended explanation from. So, what do you think about this?
On facts and idea, right?
On the facts from nature, things that exist. Yes, there was proposed. Let's just follow up because I don't think I understood if there is a legal point actually.
Yes, no, I think that's the key difficult question about trying to tackle with open licensing model also technical factual data, because most of these technical data may have no specific exclusive right, such as intellectual property, and Professor Gray mentioned back the WIPO notion of creation, of the intellectual creation. So definitely technical raw factual data may have no exclusive right, and therefore instead there may be some reappropriation by some businesses, or we try to extend some open licensing model to that data as well via some legal fiction, or as I mentioned, via contractual tools.
So for those of you who have questions on Zoom, please don't hesitate to raise your hand and we will give you the floor.
So if there is no further question, I would give the floor to the panelists for a last opportunity to speak or perhaps to ask a question to you, Professor Loison.
Very much. I would like to come back to the question that has been asked about ethics, and especially you answered by using the argument of incentives, and I think that's one part of the story. But the other part of the story is, at the end of the day, if I'm a citizen and I accept to share my data with a license, someone need to control that these licenses are respected. And as a data owner, probably I won't have time to do that because I just other things to do. My question is a little bit, how do you think you could solve the problem regarding that? Because just an example, I do that, I share my data with the right license, everything works well, but one day it doesn't work well at all. And I'm not sure that I will be able to identify that. That's the first thing. The second thing, I will have to bring the data trust probably in front of the court, and it costs something for me. And to a little bit the question that I have regarding what are the consequences. I mentioned that, but read the consequences for the end user, the data owner at the end of the day. Because currently, as I mentioned in my comment, it's a little bit another model that apply, which means the end user, the data owner, at the end of the day, transmit the data to an organization, and the organization has to take the responsibility how they deal with the data. And it's very clear that if they don't deal correctly with the data, they have to take the responsibility. I'm not so sure how you could answer to this question, because in my eyes, you shift a little bit the responsibility to the data owner with this license. Well, maybe I'm wrong with my reflection, but I think at the end it's a bit like a software, open source software. I write a software open source, and something is misusing my software, as I'm responsible for that. Probably I have enough resources to take care of that, but a single citizen, probably I don't have time to do that. And no one will remark that, will see that, will notice that. Just a question or some thoughts about
conclude in the middle.
I have.
Okay. Yes, I think that's where the collective dimension of data is interesting with data trusts, for instance, to manage and license the data. That's why I made comparison with the copyright collective societies, because they enforce some copyright infringement. They collect the royalties for reusing copyrighted works. Similarly, data trust may work exactly the same. They would enforce or collect the benefits, or assuming that they do monetization or try to enforce in case of data breach. Now, when you talked about liabilities and shift the liability from the data trust, or actually that it's still within the data owner, the data subject. Yes, so that's the liability typical question of open licensing, and it's very limited. I think the liability of the open source developer or the data owner who would put the data in the core. So that would be very limited, I think. And final word on collective dimension, I think, because data subjects or data producers sometimes are so small, it's very interesting to bring that collectively. And another way of bringing the collective dimension of data is also to exercise the data collectively. And I usually mention the example of Uber to my students, because Uber drivers also made, for instance, a collective claim so as to better understand the transparency of Uber. So collectively, whether via the exercise of access rights or via licensing, I think that's an interesting way of gaining sovereignty and control rights.
Thank you very much.
Thank you very much. I think this is just a quick comment on that, which is very interesting to observe, which is this perhaps paradigm shift from individualized or highly individual rights, because perhaps there is nothing more personal than personal data and the rights on personal data, and the shift towards the collective exercise, as you just mentioned, to see how we can manage to move away from really individualistic exercise of individual rights to more collective by using third parties, including data trusts, which is certainly something on which we have to continue to discuss and to work collectively in order to find relevant solutions. If there are no further questions or comments, and I'm turning to the audience and to the remote audience, I would stop here by thanking very much our speaker. Oh, is there a question from you, Melanie? Did you raise your hand?
Oh yeah, I wanted to applaud with both hands to the last comment on the collective aspects as opposed to the individual aspect of this licensing and the organization, which could be based on the model of collecting societies. And I wanted to bring also the perspective, in addition to the collective, the perspective of the commons, which could apply both to the licensing conditions and also to the design of the institution, which will be needed to manage this this resource. That would be the final comment which just came to my mind, listening to your concluding remarks. Thank you.
Thank you so much. We'll have ample opportunities to continue discussion, but perhaps not today. So let me thank again our presenter, our commentators, and also the audience for the discussion. And we look forward to other opportunities to interact on these most stimulating issues. And we also wanted to remind all of you that you're most welcome to join us remotely or face-to-face for the next session of AITPT, which will take place on September 29th, and the information on our Digital Law Center website. Thank you very much, and stay safe, and wishing you all a very good evening.